All right, we'll go ahead and get started. My name is Chris Berry with Castle Wealth Group, and we do these weekly webinars almost every Wednesday, where we just provide information, answering people's questions that they submit, either while we're on the webinar or previously via email. And I always like to start with positive focus, just something positive that happened over the last week or coming up. And for me, positive focus is my son, who's 13. He's in band and he's going away, going to Cleveland to listen to orchestra and do some fun things in Cleveland this weekend. So pretty excited for that. So with that, we'll go ahead and get started. Again, if you do have a legal, financial, or tax question or something I talk about is unclear, you need some more information, just put it into the Q&A and I'll try to address it. There's nothing kind of scripted or prepared. It's just based off of what people submit or ask. So with that, I'll share my screen. And so this was submitted. First question is, should I make a trust the beneficiary of my IRAs? Answer like a lot of questions is it depends. It depends on a lot of times what type of trust you set up. So if the trust says like outright to the kids at 25 and the kids are older than that, then really it doesn't matter because it's just going outright to them anyways, and it might be just a little bit more paperwork. But if you have what we call legacy provisions, where instead of it going outright to the kids, it goes to them in trust, and it's held in trust. So like your one trust would split into separate shares, one share for each kid. Whatever each kid inherited, instead of it going outright to them, it would be held in trust. So it'd be like the mom and dad trust for the benefit of John, the mom and dad trust for the benefit of Sue or whatever. So if we have these legacy provisions or separate, oops, hit there, separate share trusts, then we would certainly recommend naming the trust beneficiary. In our office, we almost always name the trust as beneficiary. Typically, it's going to be spouse first, then trust. And just because some people, and even some financial advisors, and used to get a lot of pushback on this, and I just got tired of providing the education. And this was a bigger issue before the Secure Act. So what the Secure Act did is it said that if a beneficiary other than a spouse inherits an IRA, instead of them stretching the taxes over their lifetime, they have to pay all the taxes within 10 years. So prior to 2020, if a kid inherited an IRA, they could stretch all the taxes over their lifetime. And there are some concerns from maybe unsophisticated advisors that if you name a trust as a beneficiary, that you'll have to pay all the taxes within 5 years because it doesn't qualify as a designated beneficiary. That could be true if the trusts are set up incorrectly. We've been doing this for 20 years. We used to do retirement plan trusts to force that stretch out over their lifetime. So in our office, 99% of the time, we're naming spouse as a primary beneficiary and then trust as a contingent beneficiary, because the only way the beneficiaries can get the benefit of the trust is if it's listed as a beneficiary. If the trust is listed. If it's not pointing to the trust, then the provisions of the trust don't apply. So at least in our office, we almost always name spouse first and then trust as contingent beneficiary on any IRAs. There's no downside to it. And only upside. So pretty straightforward. Does a castle trust serve this purpose, or does it require another trust? Yeah. So in our office, we kind of break the planning into 3 different levels of planning. We have a base plan, base trust plan, which is a revocable trust with outright distributions. So you just want to avoid probate. Then we have what we call our legacy plan. Our legacy plan, that's the revocable trust, but builds in the protections for the kids, building in those separate share trusts. So whatever the kids or beneficiaries inherit from you are protected from divorces, creditors, and the money stays in the bloodline, versus outright distributions, which most trusts that we review, when someone comes in with a estate plan, a lot of times it says outright to the kids at 25, 30, or 35. But all you're doing is launching a pillowcase of money over the wall of time. Like what happens if the kid gets divorced at 36? Half the money could be lost. Or what happens if they pass away? All the money might go to an in-law who we call an outlaw who might remarry versus going down to grandkids. So a lot of times we're either doing a legacy trust or the Castle Trust, which builds in asset protection for you, protecting from long-term care costs, but then also includes those legacy provisions for the kids as well. So if you have an IRA, we would name the trust as the beneficiary, like almost all the time, spouse and then trust. Whether it's a base plan, legacy plan, or castle plan, in our office, we're always naming the trust as a beneficiary. So then next, how does this affect taxes? What are the best tax options? Really, it doesn't have any effect on taxes because, like I said, the way that we structure our trust, they qualify as what's called designated beneficiaries. So from a tax perspective, if you name the trust or an individual outright, it has the same tax consequence. And that tax consequence is with the Secure Act, if the kids or anyone other than a spouse inherits any pre-tax dollars, tax deferred dollars, all the taxes have to be paid within 10 years, whether you name the trust as a beneficiary or you name one of the kids outright as a beneficiary. So there's no negative tax consequences by naming the trust as a beneficiary. And that's where a lot of our clients, especially given that taxes are going up in the future, a lot of our clients are looking at strategically while you're alive, pulling money from the IRAs, paying the taxes, and then investing it somewhere else. So now whatever the kids inherit will go to them tax-free versus being forced to pay all the taxes on your pre-tax accounts within 10 years, which is what the Secure Act did. And so that's been in effect ever since 2020. Okay. So hopefully that was helpful. All right, next. Let me see here. All right, here's a couple of questions. I apologize. This was from last week, but I missed it in my email. So let me share my screen. And here. Okay. All right. So for us folks with no children, parents deceased, with similar aging siblings, yes, nieces and nephews, what are the options regarding who to name executor or trustee? Whoops. Oh, that's fine. What I always do, we kind of have a hierarchy of who to serve as agents. So I always look to family first. And again, you might not have kids, then you can look to siblings and name nieces and nephews. As well, you could look at cousins, so family, like nothing's stronger than family and blood. And then if not family, then friends, maybe a close family friend, someone from church. I've had clients name their pastor or religious leader. So just friends. Then you can get into professionals. Like attorneys can serve, CPAs. We try not to serve on documents that we created just because I don't want any appearance of like too much control. But we do serve occasionally. And keep in mind, you might not have a perfect answer, but whoever you come up with is going to be better than leaving the courts to decide. And that's really the final answer is if you don't name a family member, a friend, or a professional, then what's going to happen is then the judge is going to appoint someone. And what they're going to do is appoint a court-appointed lawyer, typically, who has 250 other people that he or she's managing this for. And so this is where you get into trouble. So first family, if not family, then friends, if not friends, then professionals. And keep in mind, whoever you name is better than letting the courts to decide. All right, see a question come in. I'll get to that. Can we name a family member as a trustee executor who's a citizen of and lives in a foreign country overseas? Really would prefer not. So I would go with no on that one. If they are a citizen, like they can, but I really would prefer not to go that route. In situations like that, what we've done is we've named someone local that would work with that person. So I'm thinking of a specific client situation. They had the perfect person was like out of the country, but they had someone that they trusted that would work with that person to get things done. So ideally, yes, they're in the U.S. Doesn't have to be in the state, but it should be in the U.S. Heard of a professional executor, professional fiduciary? Who or what is this, and how much does it cost? How do I find one in Michigan? What qualifications would I look for? State licensed. Um, First, I would look to attorneys because we have the highest level of fiduciary responsibility, like attorney-client privilege and all that. That's super important. But there are non-attorneys that also serve this role. How do you find one? Like Google, I guess. I've probably met some throughout my career, but again, it's going to be more costly, and typically they're going to charge hourly, and sometimes those charges can get pretty expensive depending on what's going on. You can also look at like banks. Some banks have trust departments, but now you're really slowing down the process and you're looking at a lot of fees. And sometimes, unless you have like over $1 million, they're not even going to serve. So ideally, family, not family, then friends. My employer offers a legal plan that offers state-specific boilerplate documents, which I guess I just fill in the blank. What do you think of this approach versus working with an independent agent? Does having a simple estate, only owning a house and financial assets versus complex, like rentals, influence that decision? Uh, I would say you get what you pay for. You can go online, like Susie Orman has a estate plan you can download for $15. I've worked with a lot of clients where we've had to clean up the messes because of that. And while it's one of those things where you don't know what you don't know. So you could have a situation that you might think simple, but you might have some blind spots that would add some added complications. And sometimes people assume that, hey, because I don't have kids, like it's simple, but actually that can make things more complex. So you can certainly do it. Just like if you got arrested for like a drunk driving or something, you could represent yourself in court. You don't need a lawyer to do this stuff. You can just go online and print out your own documents. And, but again, you don't know what you don't know. And really, it's not just, hey, here's the document where we're providing value. It's also on the counseling and just helping you understand the blind spots. So you can certainly do that. I go online for silly things like I hurt my elbow, I'm going to WebMD and it's going to tell me I have elbow cancer and I'm dying. So that's where, especially things that you find important, you might want to work with someone who does it professionally. All right. And then again, I got one last question. So if you do have any other questions, feel free to put it in the Q&A. Another positive focus is we're about done with tax time. So that's good. There's a busy time each year when we're around tax time. All right, and then this last question that I have that just came in, share my screen. LLC should be created prior to a trust. In terms of the order, like if you have rental properties or something, should those be put into the LLC before you create the trust? Typically, we do it all at once. Like that's one of the things we do is we set up real estate or LLCs for our clients, and then we assign it to the trust. The order really doesn't matter, but typically we would do it all at once. So there's no advantage to setting up the LLC ahead of time, other than at least you get it done. So I would say whatever you can get done as soon as possible, get it done. You never know when life's going to throw you a curveball. So, but in our office, typically if we're working with clients, we're doing this all at once. Okay, we see that you have multiple properties. You don't have a trust. You don't have the powers of attorney. Let's just knock it all down at once so we can just be done with it. You can get on with your life. Okay. And any other questions? Going once, going twice. All right. If you do have something, feel free to email it over and we'll take care of it next week. But with that, I want to thank everyone for taking time out of their day to listen to me blabber on about death and taxes and all that fun stuff. And We are doing a lot of workshops right now, educational workshops. I had one this morning in Novi. We have another one this evening in Cleary or at Cleary and Howell. So if you want to see how this information applies to you and you haven't set up your estate plan or you're getting near retirement and you have a lot of tax deferred money and you're looking for advice, our in-person workshops are going strong right now. Or if there's a family member or friend that wants to get started on planning for retirement uh, and getting their legal, financial, and tax ducks all in a row, then we invite you to contact our office and we can send you a schedule of our upcoming workshops. So with that, thank you everyone. Make it a great week.